Good morning and happy Thursday. I hereby call this the second meeting of the House Standing Committee on Families and Children to order. As a reminder, please silence your cell phones. DJ, please call the roll.
Representative Bojanowski,
Here.
Representative Callaway, Representative Kleins, Representative Dietz,
Here.
Representative Doan,
Present.
Representative Duval,
Here.
Representative Elliott, Representative Holloway,
Here.
Representative Mosier, Representative Pollock,
Here.
Representative Rayburn, Representative Riley, Representative Rorks,
Here.
Representative Stalker, Vice Chair Wilson, Chair Heverin.
Here. Thank you. As a reminder, we do have a few committee members out this morning just because of icy roads, but also please keep Representative Riley in your prayers. His father passed away last week, and he is at visitation and the funeral tomorrow. So please keep his families in your prayers. It's, as we all know, it's very difficult to lose someone you love, much less a parent. We're going to go a little bit out of order today on the agenda. First, we're going to do House Bill 479 by Representative Lewis. If you could please make your way to the table with your guests. Please introduce yourself for the record. If you are new here, you'll see a green light come on.
Thank you, Chair and members of the committee. Derek Lewis, State Representative of the 90th District, proudly representing Clay, Laurel, and Leslie County.
Mackenzie Wallace, Director of Public Policy for the Alzheimer's Association.
Adriel Camille, State Representative, House District 93 in Fayette County.
Please proceed.
Thank you, Chair. So this is a very straightforward bill, and as you can see, my primary co-sponsor is of the other party. What you will find is dementia is not partisan, and it is something that has affected all of you. I've been working with the Alzheimer's Association, and Ms. Mackenzie Wallace here has included in your packets statistics for every one of your counties and the rates of dementia for individuals 65 plus. What you'll find is statewide, the rate is 10.4%, which was staggering to me when I learned of this. But what this bill does is it requires 1 hour of dementia training for DCBS workers. It is offered free by the Alzheimer's Association or any other entity that meets the required metrics. It's very straightforward, and I think it's something we need in the state. We won't argue.
I have a motion by Representative Pollock and a second by Representative Stalker. Does anyone have any questions? And just to share, this does not have a fiscal impact.
Correct.
Or a fiscal note attached. Okay, so we have a motion and a second. If there are no questions, DJ, please call the roll.
Representative Bojanowski,
Yes.
Representative Callaway, Representative Kleins,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Duval,
Yes.
Representative Elliott, Representative Holloway,
Yes.
Representative Mosier, Representative Pollock,
Explain my vote. I'm a yes in honor of my mother-in-law, Miss June Bishop, and all the families and people are dealing with dementia, which is an awful, awful disease. So thank you.
Representative Rayburn, Representative Riley, Representative Rorks,
Yes.
Representative Stalker,
Explain my vote. I'm a yes, and I just want to thank both of the bill sponsors for working on this in collaboration with the Alzheimer's Association. This is really important, and more people are being affected with this horrible disease, and it's an incredible strain for the entire family. So anything that we can do to get people the training and recognizing those signs early is really critical. So I want to thank both. This is a good bipartisan effort.
Representative Wilson, yes. Chair Heverin.
Yes, the bill passes 11-0 with favorable expression and should do so on the House floor. Thank you, Representative Lewis.
Thank you, Chair, members of the committee.
Thank you.
Next, we will hear House Bill 574, Representative Dossett and Representative Lewis. Are they? Okay. Representative Dossett, and then Wesley, do you care to come on up? Thank you. Here's the man of the hour. And then, of course, we have Commissioner Dennis on Zoom with us this morning. All right. Representative Dossett, please introduce yourself and have your guests introduce themselves as well.
Absolutely, and I apologize. I was in natural resources, so covering a lot of territory this morning. I'll let my guests introduce themselves.
Representative Scott Lewis, District 14.
Yes, thank you. Wesley Duke, General Counsel of the Cabinet for Health and Family Services.
Myron, go ahead and introduce yourself.
Absolutely. Representative Myron Dossett, 9th District, Christian County. I want to thank you, Madam Chair, and thank the committee for hearing this legislation this morning. This is my 19th year of serving in the General Assembly, and I truly believe this is the most important piece of legislation that I've had a part in working on. Thank you to the chair lady for putting the work group together here over the summer. Thank you to the cabinet, to the judges, to the state police. Thank you to our chair of judiciary in the House, Daniel Elliott, who sat in and to make sure what we were putting together would be fair to all involved, to the parents, and especially to the innocent child. Special thank you to the staff of the Joy Closet, which is an agency in Hopkinsville that works with foster families, foster parents, foster children, providing services and aid to those families to help them go through trying times as a new child is coming into that. And especially in that staff, Heather Gray, Tressie Wells, and Melinda Zimineski, they were the ones who brought this to my attention 2 years ago. And we worked on putting a bill together that I filed last year, House Bill 360. Thank you to Ben Payne with your staff, who has put up with me for 2 years, and actually us going over and reviewing what we were putting together. And I also want to say thank you to my former colleague from Christian County, Senator Whitney Westerfield, who, when we originally crafted the first piece of legislation, Senator Westerfield, who was chair of Judiciary in the Senate, went over to make sure that we were putting in a presumption for those parents that had the children, to make sure that they had an opportunity. I believe in second chances. When individuals make mistakes, I believe in second chances, but for the innocent baby, that infant that would come along, be born to a family, children had been removed because of abuse or neglect, that child only gets one chance. And I do not want to take a chance that something happens and we lose that innocent child, because all that they deserve in life is to be hugged, loved on, and have a family that offers them the opportunity to have a happy life. They deserve that. Right now, I want to hand this over to my good friend, Representative Lewis, and let him explain his involvement in this legislation.
Thank you, Representative Dossett. Thank you, Madam Chair, for letting me present here today, and for all the hard work that was done on this bill. And I really believe that when you get everybody together and all the stakeholders, you have a better bill in the end. So thank you for that. the reason in my involvement is, and I'll give you a little bit of background, try to be brief, but this bill is to be called the Baby Maya bill, and this is a little background on why. This bill is not to put any blame on anyone, but put guardrails in place to try and prevent a case like Baby Maya's from happening again. The ultimate blame rests solely on the parents, who had the responsibility to protect her but did not. Baby Maya was found in her home dead and wrapped in plastic at 8 months old. When her autopsy came back, she had meth in her system. Baby Maya's parents had 3 other children who were removed preceding Baby Maya's death. After leaving the hospital with her parents, Social Services was unable to locate the parents to check on her. So she went 8 months with no one to check on her because they couldn't find the parents. So what this bill does, we try to put some guardrails in place to make sure something like this doesn't happen again. And one of the things that I was wanting to see happen, and it's in the bill, is after 14 days, if they can't be located, the state police or law enforcement's called to make sure that we try our best to find the parents and hold them accountable. So that's my involvement. And from this point on, if we pass this bill and it gets through the session, this bill would be honored to honor her, the Baby Maya bill. So I want to thank you.
Ladies and gentlemen, House Bill 574 is child protection legislation. Section 1 would amend KRS to require any person with reasonable knowledge that a child has been born to a parent that has had other children removed from their custody because of neglect or abuse, that they would report that child being born to Kentucky State Police, a local law enforcement agency, the Cabinet of Health and Family Services, Commonwealth's attorney, or a county attorney. Section 2 would create the rebuttable presumption and place that in KRS that would allow that child to be removed. But it also establishes a process for an individual to challenge that presumption, to be able to keep that child. If they are going through what is required by the cabinet, whether it be any type of counseling, anything along that line right there, that allows them to keep that child, because if they're doing what they should be doing, they are trying to be a good parent. Section 3 would amend KRS to conform to the new requirements, and that will allow the Cabinet of Health and Services, as it received notices, to be able to investigate. Section 4 will establish the ex parte emergency custody order so that that child could be removed in the event that there is still chance of harm to that child. Section 5 changes KRS to conform to these new requirements and be able to take in the rebuttable presumption that the child is in danger. Section 6 will name this legislation the Baby Maya Law. Be happy to answer any questions.
Representative Rorks.
Thank you, Chair. I did want to ask a question about, does this add to the list of who becomes a mandatory reporter, and are there any legal repercussions for those individuals not reporting?
Yes, Representative Rorks, I can take that. No, I think as Kentucky's status as a mandatory reporting state will not change, and I think the same obligation applies to anyone with knowledge of this. So it doesn't add, because like I said, Kentucky is a mandatory reporting state anyway, and it's very, very broad. So that responsibility is still there for people who are aware, no matter what their role is.
Thank you, Chair. I just wanted to clarify. And then, so is there any repercussion for folks that maybe have not reported? I'm thinking of, like, if family members maybe would have be assumed to have known that there was an open case and they did not report to the cabinet that another child had been born, would there be any reason that they would be in harm's way of legal repercussions for that?
There's nothing new in regard to that. Like I said, Kentucky has that mandatory reporting statute, and that obligation and responsibility is there. This doesn't add another potential, like you said, a repercussion of it. I mean, there's still that requirement and there's still that responsibility. So there's nothing new in regard to that.
Thank you. And before I go to Representative Stalker, I do just want to make one clarification. Representative Dawson, you did a great job going through it. On page 5, section 2, basically the rebuttable presumption, it allows the cabinet to make an initial determination. So the child isn't automatically taken away or anything like that. So it's not a loss of parental rights. It's just a check-in. So if you're, the cabinet has that opportunity, if there's a report made, because we are a mandate state, the cabinet can come in and make an initial determination. Representative Stalker.
Thank you so much, Chair. 2 questions on my part. One, you'd mentioned that there were multiple stakeholders that were at the table during the interim parts of this. And what I'm curious about is, was there any conversation with our hospitals? Because it is I'm under the impression, I did meet with some hospitals within my district after this event occurred. And please correct me if I'm wrong, but I'm under the impression that one of the things that led to this very, very horrific situation is that there might have been a release of mother and child prior to results being brought back that would have found traces of drugs in the umbilical cord of the baby. So if there's anything that you can speak to that first, I'd like to share that with everybody.
Absolutely. And Representative Stalker, I want to thank you for contacting me last night. I appreciate that you reached out to me asking that question. Hospitals were involved.
I'm actually going to take this one, Myron.
Yes.
Thank you,
Thank
Representative
you.
Stalker. Yes, the hospitals were involved. Of course, because this is an ongoing case, we've not been able to see any of the baby Maya from the child fatality review panel because now it's criminal. And so we don't have any, we can't disclose, or we don't know anything specifically that happened in the case in regards to that. That we did have Kentucky Hospital Association has been part of the conversation from the very beginning. They are very aware of the conversation of our baby's test. We've kind of re-educated ourselves on this, I'm going to say, in the work group. But we can't specifically talk to the baby Maya case, Representative Stalker, because we don't know specifically. But there are ongoing conversations, and specifically we talked about with the Hospital Association being able to share important information like addresses. Like, that's not a violation of HIPAA if you share an address with somebody, because if they're on Medicaid or Medicare, they would have their address in their system. And so being able to share that information with law enforcement. So that's one thing we feel like we could do better, because with HIPAA, there are actually cutouts or carve-outs for law enforcement. So we are having conversations with hospital associations. They were at the table, and they are very aware that I was not very happy with how things have been going.
And then my second.
Yes.
My second question also revolves around partnerships with the hospitals. So when I met with some hospitals within my district personally, one of the questions that I had for them is do you have any sort of shared systems to determine when a child is born if there is an active CPS case and status? And so maybe that's a better question for the cabinet to talk about partnerships, but from the information that I was given last year, the answer was no. So you might be literally leaving it to the discretion of somebody's willingness to be truthful with you. Oftentimes when you go to a hospital, I, as a former foster parent, have been asked the question, do you have an active CPS case open on you, No, the answer is no, but this is not my biological child. I'm bringing them in for X, Y, and Z. So if we can discuss, any sort of partnerships or ability to share information, I think that's an important part, especially if we're talking about cases that involve drug abuse and misuse.
Yeah, and that might be a better question for Commissioner Dennis, but I can speak to that the cabinet would be very interested into setting up some type of a system or an interface with hospitals and hospital systems to be able to exchange information better. I think that would help both entities in performing their functions. And once again, if Commissioner Dennis wants to chime in on Zoom, I'm sure she's probably got an opinion on that as well.
Yes, and I will, Representative Stalker. All hospital employees are still mandated to report, so that's also kind of back on the with Kentucky being a mandate state. Any hospital employee who suspects anything should should report. Commissioner Dennis, I will let you go ahead and answer that too. If you'll just introduce yourself for the record at the beginning.
Good morning. I am Lisa Dennis, the Commissioner for the Department for Community-Based Services. And to answer the question, I agree with Wes with regards to our desire or willingness to partner with our hospital associations with data sharing. Currently, we do not have a way to share data between the cabinet and hospital associations. So yes, we would be open to talking about that. And you're right, Representative Stalker. Unless the parent discloses, the hospital may not know. But if there's other concerns such as substances identified or suspected use, then again they would be reporting, and the department would be looking to see if there have been prior history.
Are there any additional questions? All right, seeing none, do I have a motion on the bill? Motion by Representative Wilson and second by Representative Pollock. All right, all in favor? Oh, sorry. DJ, please call the roll.
Representative Bojanowski,
May I briefly comment? Okay.
Yes.
So I watched a few clips about baby Maya last night, and it's so devastating. And so I'm a strong yes in the hopes that this will protect all the other children from her fate. So thank you.
Representative Callaway,
Aye, and record my presence, please.
Representative Kleins, yes. Representative Dietz,
Yes.
Representative Doan,
No.
Representative Duval,
Yes.
Representative Elliott, Representative Holloway,
Yes.
Representative Mosier,
Yes.
Representative Pollock,
Yes.
Representative Rayburn, Representative Riley, Representative Rourks,
Yes.
Representative Stalker,
Yes, and I'd like to explain my vote, please.
Yes.
I'm definitely a yes on this. I want to do anything we can to protect the safety and well-being of children. And just another comment to be made as far as, anything that we can do to build partnerships within our hospitals and sharing system information, I think will be very critical to this issue. So I just want to say thank you so much for this bill. I really appreciate it.
Representative Wilson,
Yes.
Chair Heverin.
Yes. Bill passes 12-1 with favorable expression. It should do so on the House floor. Thank you, Representative Dossett and Representative Lewis, and thank you for the cabinet for being here this morning.
Thank you, Madam Chair.
Okay, is House Bill 291. Representative Wilson, if you could make your way to the testimony table, and anyone that was a little late this morning, if you need to record a vote, now would be the time to do so on House Bill 479.
Thank you, Chairman. I would like to record an aye for House Bill 479.
Representative Callaway. Representative Mosier.
Yes, I'd like to note my presence and cast a yes vote for 479, please.
Thank you. All right. When you are settled, Representative Wilson, please introduce yourself for the record and have your guests introduce themselves. If you're new here, please make sure the green light is on and that you are close to the microphone.
Thank you, Madam Chair. I'm Representative Wilson, the 82nd District, Whitley County, and parts of Laurel County.
And I'm with with Kentucky Free, the Kentucky Forum for Rights, Economics, and Education. My name is Courtney Downs. I'm with Kentucky Youth Advocates.
Oh, my bad. I'm Amanda Hall, and I'm with Dream.org.
I'm Scott West, and I'm here today for Kentucky Center for Economic Policy, which is Kentucky Policy, and for the Kentucky Association of Criminal Defense Lawyers.
Thank you, Madam Chair. I'm here today to present House Bill 291, the Family Preservation and Accountability Act. I've filed a committee sub. I can maybe go through the bill, or I could entertain a motion now. The committee sub will get a little more into the weeds if I could have them speak first and then answer any questions about that.
So let's go ahead. Do we have a motion? We have a motion on the committee sub in a second.
Second.
We've got a motion in a second. All in favor say aye. Any opposed? All right. Please move forward talking about the House Committee substitute that's amended House Bill 291.
So very briefly, before I give my guests the opportunity to speak, the Family Preservation and Accountability Act addresses challenges by expanding sentencing alternatives for primary caregivers convicted of nonviolent offenses. The intent of the bill is to prioritize family unity, reduce harm from the separation of parents and children, and offer a rehabilitative approach that preserves that parent-child relationship while safeguarding child safety of the community, while taking all those things into consideration. So I'll allow my guests to speak.
Thank you, Chair Heverin and committee members. I represent Kentucky Free. We are a center-right nonprofit that is dedicated to advancing free market, fiscally responsible public policy. When we evaluate criminal justice reform policies, we ask three key questions. Is it constitutional? Does it enhance public safety? And is it a responsible use of taxpayer dollars? So I'd like to briefly just focus on the fiscal impact of this legislation. We released a report on Tuesday that shows that the state would save $74 million in direct incarceration costs. That is just savings of housing incarcerated primary caregivers. However, national research indicates that for every dollar spent on incarceration, society loses an additional $10 in indirect costs. So as we looked at this and looked at those indirect costs, this bill has the ability to add $740 million annually to the state's economy. Some of those economic and societal indirect costs that we looked at are lost wages and declining workforce participation, which weakens Kentucky's economy, higher foster care costs as children lose parental support, lower educational outcomes for impacted children, which reduces their lifetime earning potential, and a greater likelihood of future criminal justice involvement for children of incarcerated parents. Evidence-based alternative sentencing programs, such as probation, house arrest, and supervised rehabilitation, cost a fraction of incarceration, while delivering better public safety outcomes. For example, Kentucky's own drug court has significantly reduced reoffense rates while saving taxpayer dollars. By shifting nonviolent caregivers into structured alternative programs, Kentucky could save tens of millions of dollars per year while keeping families intact and reducing future criminal justice costs.
Maybe I'll jump in and explain a little bit more of what the bill does really quick. Upon a motion of a criminal defendant at felony conviction, they can ask the judge to consider their status as a parent, as an involved member of the household, and the judge has to determine whether that's true. If that person is an involved parent, a productive member of the household, and that's all the judge, as far as this bill goes, that's all the judge has to do. They just have to consider, they have to make that determination, and then they consider what sentence to give. This would add other options to the sentencing options for the judge, specifically services like counseling, parenting classes, the type of services that are normally involved in family court and DCBS, the type of services related to the family that are not currently available in criminal court. So I was just sitting there thinking, people may be wondering why and what this really is. So I wanted to just throw that in there before I let them continue.
Just to clarify, Representative Wilson, this bill does not require judges to give this alternative sentencing. It just gives them another tool in the toolbox.
Absolutely,
to see
that's
what
that's
best
absolutely
helps family and
correct. The only
children.
thing it requires is, upon motion of defendant, it requires them to decide, yes, this is a caregiver of a dependent child, or no, this is not a caregiver, or caretaker. I mean, there are parents who are not caretakers of their dependent children, and I'm sure there will be some of those folks who ask for this. This bill is not for those folks.
Thank you. Please proceed.
Good morning, Chairman Heverin and members of the Families and Children's Committee. My name is Amanda Hall, and I work at Dream.org. I'm a lifelong Kentuckian, currently living in Louisa, so my ride here was rough, y'all. Very glad I made it. And I have a deep and personal connection to the issue of parental incarceration. I grew up in low-income apartment complexes and trailer courts and shuffled around, and I lived a life of poverty that was incredibly hard. On top of all of that, when I was in second grade, my mom was arrested, and it devastated me. Even though she was only incarcerated for a short time, it left a lifelong impact. I vividly remember going to school the next day and seeing the newspaper on my teacher's desk with a description of my mom's arrest. I felt an overwhelming sense of shame, and that feeling stayed with me for years, along with a lot of anger. No one ever offered me counseling or reassured me that things would be okay. I just carried all those emotions inside me. My mom was an incredible woman, a survivor of domestic violence, and the strongest person I ever knew. She struggled with mental health issues and unresolved trauma that no one ever helped her address. But despite it all, she did her best. And like Loretta Lynn said, we were poor, but we had love. Due to how much I knew my mom had suffered, all the struggles she faced, after her arrest, I lost trust in people, and especially authority figures. As the years went by, my mental health deteriorated. I was consumed by anxiety and depression, and I just didn't know how to process that. Unfortunately, neither did the adults in my life. I started experimenting with drugs, and after being prescribed prescription opioids, I became fully addicted. My arrest followed, and things kept spiraling downward. I was a young mother. I had my first son at 20, and while I was able to stop using drugs for short periods of time, I just didn't know how to live without them. In my mid-20s, after my second son was born, I was arrested and sent to prison. My children then had to endure the same pain that I did. While I was incarcerated, I missed their first steps, their first words, and my oldest son's kindergarten graduation. It was devastating. I hated myself for what I'd done to them, and I couldn't understand why I couldn't change. It wasn't until after I left prison and hadn't seen my kids for years that I finally got help. I got help for my trauma and mental health and substance use disorder. I've been in recovery now for over 12 years. But even now, my incarceration haunts me. The deepest pain I feel is regret and the mourning for all that I missed in their lives. We have a good relationship today, but I can't stop thinking about the pain that they went through and constantly worry about them. In Kentucky, around 13,000 incarcerated people are parents. When families are separated, their children often face obstacles in health, education. These obstacles have lasting effects, impacting entire households for generations. I was lucky, and I had family to step in, but many children with incarcerated parents end up in the foster care system. I want the cycle for my family to end with me. So far, I think it will, but the fear remains. They've had to bear the weight of the world as innocent little boys. I know I made mistakes, and I deeply regret many of my choices, but I truly believe that access to help and resources would have done far more for me and my boys than the trauma of incarceration. While being locked up was painful, by far the worst pain was being separated from my kids. There's no greater pain for a parent than losing their children. This bill will give courts the option to consider non-jail alternatives for parents who are primary caretakers. This would allow parents to take responsibilities for their actions while staying at home and participating in programs that would benefit the entire family. I believe we should focus on keeping families together when we can. Stronger diversion and mitigation laws are a practical and effective alternative. They help families stay together. I hope that we can work together to prevent other families from going through what mine did. And thank you so much for allowing me to be here.
All right. My name is Courtney Downs. Again, I'm with Kentucky Youth Advocates, and I just want to thank Chair Heverin and members of the committee for hearing us today. We know that children thrive when they have healthy and stable relationships with the caregivers in their lives. Unfortunately, there are far too many Kentucky kids who have experienced having a parent incarcerated. Data from 2023 showed that more than 102,000 kids across the Commonwealth have experienced parental incarceration at some point in their lives. That's nearly 11% of our child population, and one of the highest rates in the nation. Parental incarceration is often described as a shared sentence because of the profound effect that it can have on children. As many members heard from Bloom, Kentucky in the interim, parental incarceration is an adverse childhood experience, which are traumatic experiences occurring in childhood that are often associated with negative long-term outcomes. So for very young children, we know that connection is foundational to their healthy development. And depending on how long a parent is incarcerated, that separation can either weaken their bond or prevent it from ever forming. And then beyond the physical absence of the parent, it can be incredibly traumatizing for a child to see their parent arrested or in court. There's also a stigma attached to having a parent who is incarcerated, and that can sometimes result in a lack of support or even some self-isolation. We see higher rates of depression and anxiety and shame among these children, as well as increased risk of dropping out of school. And for kids who have experienced parental incarceration, they are more likely than kids who haven't to also experience other adverse childhood experiences. So things like separation, their parent separation or divorce, violence in the home, as well as parental substance use. We also know that there are financial hardships that can come with this, as well as instability. There are research that shows that children are more likely to experience a disruption in their living situation, so typically having to move in with a kinship caregiver or a fictive kin caregiver, especially if it's their mother who is incarcerated. And even being incarcerated for a short period of time can result in a parent losing their job, and then also making it harder for them to find employment upon their release, which obviously impacts the family and the community workforce overall. So I understand that talking about the impact that this has on children can feel like a very heavy topic, but the persistently high rates of kids who are affected by parental incarceration creates an urgency for us to minimize the impact. And with House Bill 291, parents can be held accountable in ways that promote public safety while also minimizing the negative impact on children. Thank you.
My name is Scott West, and I have my own practice now, but for 26 years I was a public defender. I was in the Hazard office, and then the Murray office, and then the Richmond office, and then the Frankfurt office. And I counted up one time, I have appeared in court as a criminal defense attorney in over 40 counties. And I've seen a lot of sentencing. And I want to say that this bill is carefully crafted not to step on the discretion of judges. It uses the language "shall consider." That's the language that is already in the existing probation statute. The way it works now is a judge shall consider, if it's a probatable case, it's not a violent offense that can't be probated. A judge shall consider someone for probation by looking at the criminal record of the defendant, the character of the defendant, the risk assessment of the defendant. And if they're not a candidate for probation and they still remain a candidate, if they still remain a candidate for probation at that point, after that consideration, then the judge shall probate unless the judge finds that probation would depreciate the seriousness of the offense, if the judge is of the opinion that this person may commit another offense if released, or if the judge is of the opinion that there are services in the prison that will help address better the defendant's issues than the community. And if the judge is of the opinion of those, then the person is not probated. And it doesn't require a written finding for that. But in fact, it becomes a written finding. Almost every judge that I have ever been in front of uses the administrative office of the court's form, and those three things are in there. And it's a checkbox. If the judge is of the opinion that it will seriously depreciate the seriousness of the crime, they check that box. I don't speak for the administrative office of the courts, but I imagine that if this bill were to become law, it would find its way into the form, and it would be one of the things that the judge can make a decision of. The motion must be filed by the defense. The defense has all the burden of bringing forth any evidence. A judge can't consider something that doesn't have the evidence in front of them. And I'll be honest, and I'll have criminal defense attorney friends who'll get on to me for this. But a lot of the problem is the criminal defense bar has not been as attentive as it should be to family issues. And the reason for that is we become laser focused on the criminal record, the risk assessment, the character of the defendant, those things that are in the statute. If this were passed, even the most unimaginative defense attorney will have a roadmap for putting things before the court. I'll be honest. I was pretty good about bringing to light that this person went to a rehab, or this person, had clean drug screens, or this person held a job. And I wasn't so good at this person is the one who teaches his son how to play Little League, and his Little League son is a star. This is the lady who helps her daughter get through school, and she's a straight A student because the mother is there to help her with her math because she's good at that. This bill would focus attention on that, and we passed a lot of those. We passed carjacking last year, and I'll tell you the way that it's written, nobody is guilty of carjacking that wouldn't have also already been guilty of first-degree robbery. So why do we have carjacking if first-degree robbery is there? Because it brings attention to it. It focuses attention on it, and we do more about it when it's there.
Motion on the bill.
I've got a motion and a second. We do have a few questions. We also have someone speaking against the bill. Judge Patricia Sumi? If you can make your way up to the table.
Chair Hebron, may I be excused to go to another committee meeting?
You may be. Thank you. Nope. Stick here. We do have about 18 minutes left before we need to be out of the room. So for members, please make sure your questions are brief. We do want to have enough time to talk about this, but please be respectful of that. Judge, please move forward.
Good morning. It's great to be here. I don't think I've appeared in this committee before. I'm Judge Patricia Sumi. I'm a general jurisdiction circuit judge in Kenton County, and used to, because I've been on the bench 29 years, also do family law before we had family courts, and prior to that also practiced family law. So primarily I do now civil and of course criminal. There's a lot of good things to say about what was presented to you. Obviously, criminal general jurisdiction judge wants to know as much as they can know about what's going on with the defendant. I already find out all about being a parent and what they have and what they've told probation and parole. I think the thing that is most daunting and the thing that is a concern is some of the definitional pieces here. As you know, because you all do this more than I do, because I no longer do family law, the word dependent has a lot of serious consequences when you're dealing in the family law setting, as does caregiver. And you're asking a general jurisdiction judge in a criminal sentence setting at sentencing to have a hearing to make a finding. And it is a written finding. And while Mr. West, who I have a great deal of respect for, and I have a great deal of respect for the background and the feelings of Representative Wilson, making that kind of determination is a serious matter to me. And it means that I'm going to have evidentiary hearings, because I do not make findings of fact without having a hearing. And so you're now putting me in the seat of a family court judge to make those findings, and I don't know that that's beneficial. I've worked with them. They've been very open about this bill, and I really am appreciative of that. I've had a long conversation with them, with the group the other night, and I can find somebody's a parent. And even if they're not a caregiver, I can certainly request probation and parole to take care of their needs, which is please give them all the resources they need. If, in fact, this bill changes to one where I can then start tapping into CFC or whatever the Commonwealth as a resource, that would be a benefit to me. But I do ask probation and parole to give people the care they need. We do, as judges as a whole, consider someone's parental status when making a determination about incarceration. I don't want you to think that we don't. We get all that information from the pretrial, pre-sentence reports, and they're very important to us. Additional information given by the defendant, which apparently the DOC doesn't request, would be great. More information, the better. I want to know about how my defendants are situated so that I can make the best decision for them and for their families and for the community. So as a whole, I think the biggest concern that I have, and I haven't talked to many of the circuit judges because this has been circulating just for a little bit, but we've also talked to Senator Rocky Adams, who I think there's a Senate bill, so I know the district courts have talked with her. Our biggest concern is about the overlap and the crossing of my making decisions about whether or not somebody is a caregiver, not a parent, but a caregiver, and how much that involves, because we all know, and you all deal with those family issues all the time, those are hearings that take a long time in which everybody's very contested. So the determination, giving someone a new status at the criminal level is where I'm concerned. Giving me more authority to give them resources is fine, and giving the defendants more authority and ability to give their information to probation and parole or to have it filed with me is fine. I just do want to mention to you that if it doesn't go to probation and parole, it does not follow them to the DOC. So I get lots of family impact letters, and they're all in my circuit file in Kenton County. None of them have gone to DOC, because the only way you get information from people to DOC is through their pre-trial, their pre-sentencing reports and interviews. So if you want to have the department as well as an automatic referral to the Department for Children to deal with families, I'm very happy with that. I think the concern we have is us making secondary findings and not long hearings. And as I said, I haven't done family law in a long time, but having a hearing to determine somebody's status is a lot. Got lots of letters to say, my husband is a wonderful man, I need him at home, but I don't know that those are true. Most of those are self-reporting. I don't have anyone to cross-examine them. So I'm in a hearing without that kind of information. So I would ask that you take that into consideration about the seriousness with I and the other circuit judges take making findings of fact and determination. So I can determine parent, and I don't have a problem with that, but making a caregiving situation by looking at their finances, I think most importantly, I think that the substitute bill has left it in there, and I do think it's important, and I do read those letters, but I don't know that I've made a finding then, but the role of the parent with the child, the relationship of the parent with the child. Does the parent take the child to school? I get those in letters, but to take that and then make a finding based on that is a lot. And so I think it's outside my scope. I think it's outside that scope. But if someone else makes that determination and they want to give me that information, I am very happy to consider that in determining whether or not somebody should be penalized. Terrible stories. It's horrible to have somebody that you love incarcerated. I can't imagine what it's like even for one day. However, making that determination is more than giving it consideration. And again, appreciating that maybe there's a form used out there. That doesn't happen in Kenton County. We have written findings ourselves, and they're all not handwritten typed, but so we don't check a box. I don't consider my job a check a box. So I appreciate it, and I do wish the defense bar would step up more, and I agree wholeheartedly with Mr. West. It would be great to get all that information. I do have alternate sentencing hearings, and I get memorandums. I read those, I consider those. So I would just ask you to consider the determination here and make it shorter. I'll consider them a parent. I'm more than happy to send them to DOC. I'm more than happy to make a list of where they need to go. I don't have the authority, and I don't think DOC has the resources for them to comply with all the things I would like for DOC to do. So I appreciate you thinking about that as you contemplate this bill. Thank you so much. Great to be with you all. Usually I'm not here.
Thanks for being here. All right, Representative Wilson, make your way to the table. Representative Pollock.
Thank you, Madam Chair. Just a couple of comments. Obviously, the lady who shared her testimony, thank you for your courage Your testimony matters. It can impact another family. So thank you so much for doing that. Just a thought. I was told here in the state there is a judge in her courtroom that if you are charged so many different crimes, I don't know all the tiny details, but I think there's 10. And typically it's toward stealing or whatever the case may be. I don't know those 10. My point is this. If you've created this crime in these 10 in her courtroom, that she sets you up to put you back to work, to give you a social worker, and over a period of time, I think it's 6 months, I don't know all the details, but that you go to work, you do the things you're supposed to do, you show up for your social worker, you do all these things, and in a matter of 6 months, then at that point, again, it's these 10 crimes that's in her courtroom that technically she'll wipe your slate clean.
I think when we pass House Bill 291, we're going to see that in a lot more counties for parents. So thank you for bringing that to our attention. That's our goal.
Okay.
I'm glad to see it's happening in at least one now.
It is.
And I'd like to, we've had long conversations with the judges, hours, and we've made changes. That's a big reason, part of the reason for the committee sub. They have a valid concern of self-reporting. It's not the defense's job to bring the judge information that is detrimental to their own case. In fact, that may be malpractice. I'm not sure. So we amended it to allow the judge to see whatever other cases are in the courthouse. If there's juvenile cases, family court cases, they're allowed to view that information in making their decision. Also, they have a valid point. A criminal judge, they don't want their ruling to bear any weight. They don't want to step on the family court's toes. We added a section that the determination that's being made under this bill is not admissible as evidence in a family court. It's not determinative of caretaker status in another court. It is only about the sentencing, about that hearing there that day. In fact, I believe that if they're there for a sentencing and they're given probation and parenting classes and they fail and they come back for probation revocation, I believe that their finding of caretaker is not even valid for the same case in a future hearing. So I'm more than willing to work with them to figure out how to make the language right for them where they feel like they're not stepping on their toes. We can make it a determination instead of written findings, but at the end of the day, judges make rulings, they make findings. That's what they do. And we're asking for them to find whether a person is a productive parent or not. And some of them already do, but I want all of them to do that. That's the reason for this bill.
Thank you, Representative Wilson. Representative Callaway.
Thank you. And I, too, would like to extend my gratitude for sharing your testimony today. And also, congratulations on 12 years. That's amazing, and you deserve congratulations on that. So keep it up. Thank you. I think my question would best be addressed by the judge. Could I do that?
Please make your way forward.
I'm going to sit there. I can't see you. Thank you for coming today and for sharing with us some of the behind the scenes that a lot of us aren't privy to. So when you say that you already take this into consideration, this is something that you do anyway, and then we talk about caregiver, caretaker, guardian, and those being three very specific words. Obviously, like you said, we look at words very closely and their meanings. When you say that you take into consideration these cases and these individuals, what are you looking at? What term are you using when you look at that? And if the case is that there are some options, this is kind of twofold here. If there are some information that you're not currently privy to, which is what we're hoping to accomplish with this, what is that? And I see that as beneficial to have more at your fingertips to be able to look at. So can you kind of clear up both of those for me, please?
Absolutely. And conversations with Representative Elliott, we've talked about the information or the Department of Corrections, and I don't want to badmouth anybody's, reluctance to accept a bunch of information from defense. And so, you know, when they interview the defendant, he tells them all about their family. Just a couple weeks ago, I had a defendant who had two 17-year-olds. You look at their age, 2-year-olds, you look at the number of children they have and how responsible they are. You find that out because sometimes they don't know the address of the child. So you automatically know that they're not really involved with that child. So I get their information. I get who their significant others were, so you know if there's more because it names who the mothers are. You don't necessarily know that they're living with that parent, but that parent can tell the probation writer about what's going on with their lives. And obviously, if they're incarcerated, it's very hard for them to bring forth the paperwork. But, you know, obviously, we're looking at those every day that we sentence somebody. We're making notes on those. And so any information that the defense, and I think the defense should be able to give that information to the DOC and to the probation office so that we get that. And I do get letters. I get letters from people's aunts, their cousins, and all those kinds of things that are very informative about how he's always helped the family do this. He's always helping with his children. He's a coach. I get that information. Again, because it doesn't go through the DOC, it doesn't follow them if they remain incarcerated. It just comes to me. But I read those letters. I mark them, and they're all a file. So we get that information, some of it formal, some of it informal. Most of it is self-reporting. But if I have a custody agreement that shows that someone really has been involved for a long time, I consider that. But I very seldom get that. That speaks to Scott's statement about, the defense bar. We look at everything that you give us. And I don't have a direct connection to the Department of Corrections. So, I mean, to the cabinet. So I'll say to the Commonwealth sometimes, have you reported? You know, have you reported this incident so that they can get those services? I think we're all in the business of trying to make sure everybody's better because everybody makes a mistake. And so, And I don't know that I can do anything about the trauma that's caused when somebody's parent is arrested, but I certainly can help deal with the trauma of how long someone is incarcerated and the services they get. But I can only provide the services that the Department of Corrections or the Department for Families and Children provide. And so if you open that link between us, more than happy if you open the link with defense counsel bringing all of that information to the sentencing people. I get to read it in advance. And we do have evidentiary hearings, but it's not about making a determination that may cross-purpose what's happening somewhere else. And while the representatives was great about making some of those changes in terms of motions so that you don't have to make that finding every time, I think that procedurally it's much more substantive to have it go through probation and parole. We'll still get motions for alternate sentencing. We'll still have those, but it won't be at that level that I am making determinations contrary. Can find their parent, and even parents who aren't caregivers, sometimes they need to go to parenting classes. So because they're eventually going to be integrated. So I don't have a problem with anybody participating. I have lots of people who are incarcerated who are participating in those so that when they get out, they can reunify. I hope that's a long answer to your short question. Sorry.
Thank you. Representative Elliott.
Thank you, Madam Chairman. Good morning, Judge, and good morning, Representative Wilson. I'm trying to understand part of what you're saying here. I think I understand it. You're concerned that in a circuit, for instance, where there's a family court and a circuit court, a general jurisdiction circuit court, if the family court is determined that the defendant was a caretaker or whatever the term, a primary caretaker of a dependent child, or maybe not, you want to be able to have access to that determination so that your determination is not inconsistent in that type of a case? Is that what you're saying?
If it's in my circuit, I can generally get that record anyway. If it is another jurisdiction, it is not going to be on KY3, and so it will be blocked. If I really need to get it, I will, and I have done that in certain cases. But again, that takes your whole staff processing that as opposed to it just coming to you. The big question is not so much me making that determination, but now that determination, although I appreciate the substitute, which took that out of something that the family court could look at, you have that conflicting with the family court. But you do then have a determination, number one, whether somebody is, and maybe even more blighting, somebody's not. And, and that can be used for things other than that, because it would be more national than just state. Hey, the judge said that I was a caregiver, so I need that tax exemption, and how we all know they fight about tax exemptions or tax dependency. So there's just a lot of ramifications to it that have me concerned.
Okay. Thank you.
Thank you. Representative Mosier.
Thank you, Madam Chair. Thank you, Representative Wilson, for being here. Thanks, Judge Summy. It's good to see you. And of course, thank you to Amanda and all that you're doing. I can't see you anymore, Amanda. Oh, there you are. To use your lived experience to really improve things for our Commonwealth and for folks going through this situation. I really appreciate all of the conversation here. And Representative Elliott really asked my question. If there are difficulties in operationalizing this, is there a way to allow a cabinet caseworker to help facilitate gathering evidence? Or I'm not exactly sure what the breakdown is in gathering evidence.
I truly believe we're going to land on something that everybody is okay with, first off. Language that facilitates their job and what we want to accomplish with this bill. The question on who can bring evidence is a difficult one because the defense probably should not bring evidence that's damaging to their case, especially if they're fighting about whether they're going to go to jail or go home. I think the bill gives the judges the ability to see the information that is pertinent to that decision. I don't know if the Commonwealth should take it to them or who. But there are programs for these families that are available in DOC, Department of Corrections, basically. If they're incarcerated, there's programs available to them that are not available out in the real world. And that's a problem. And that's what we hope to fix. We want those programs and treatment, and we want those to be accessible during probation. Because they're available while they're in jail. Clearly, there's a problem there. But as far as the evidence getting to the judge, I'm not sure I have a right answer for you. And I don't want to give any unduly burdensome paperwork to the judges, the clerks, the prosecutors. I just want what I believe Judge Summy is already doing, I want to happen in every case.
If I may just quickly follow up, I agree with you. I appreciate that. I know the work that the family courts are doing and the importance of these services being available out in the community so that we can avoid incarceration and on the other end help folks reenter if they are incarcerated. I really appreciate your work on this. I'm in support of this. I just want to find a way that really helps streamline the information that the judges need to make these determinations. And
can I just speak to the operational piece a minute?
Yes.
You talked about linkage just a little bit ago between hospitals and the cabinet. There's really no reason why you can't request linkage between the probation officer writer and the department with regard to services and tighten their relationship, because that's who I'm going to rely on in terms of the resources. I'm going to say, go to probation and parole, and this is the person who's going to be basically your case manager. And so, yeah, I think that would be, I would love for everybody to get more resources. It would be fabulous. So that's the linkage I'm looking for. Thank you.
Thank you. Do we have a motion on the bill? We already have a motion and a second. Before we go to roll call, Amanda, thank you for sharing your vulnerability. That is much appreciated. I think lived experiences make a big difference, so thank you. And just for a comment, the reason that this bill, I've been working with Representative Elliott. We've kind of talked about what bills would best fit in my committee, what bills would best fit in his committee, because we do have a lot of overlap. And this is over here because it's specifically about families and children. I've kind of heard a little bit about paperwork. You know, at the end of the day, we're here to make families and children's lives better. If it makes extra paperwork for us as adults, so be it. But what's going to make children's lives better here in Kentucky? So that's my thought on that. DJ, please call the roll.
Representative Bojanowski,
Yes.
Representative Callaway,
Aye.
Representative Kleins,
Yes.
Representative Dietz, Representative Doan,
Yes.
Representative Duval,
Yes.
Representative Elliott, Representative Holloway,
Yes.
Representative Mosier,
Yes.
Representative Pollock,
Yes.
Representative Rayburn, Representative Riley, Representative Rourks,
Yes.
Representative Stalker,
Yes.
Representative Wilson,
Yes.
Chair Heverin.
Yes. The bill passes 13-0 with favorable expression and should do so on the House floor. Congratulations, Representative Wilson. I'm going to leave it open for any vote recording. Representative Elliott.
Thank you, Madam Chairman. I need to record an aye vote on House Bill 479 and an aye vote on House Bill 574.
Thank you.
Thank you.
The next meeting of the House Standing Committee on Families and Children should be next Thursday, February 27th, 2025 at 9 a.m. here in room 171 of the Annex. Motion to adjourn.